Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court judgment pronounced now in the area of property law, especially matters involving that a decree of possession cannot be passed in favor of the plaintiff merely because defendants were not able to fully establish their right, title and interest in the property. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled Smriti Debbarma Death through Legal Representative versus Prabha Ranjan Debbarma and others, pronounced on 4th January 2023. Smriti Debbarma, as an attorney on behalf of Maharani Chandradhara Devi, filed title suit for declaration that Maharani Chandradhara Devi was the owner of the suit property. The trial court decreed suit holding that the plaintiff had right, title and interest in Schedule A property but did not grant decree in respect of Schedule B property. The plaintiff did not challenge the decree of the trial court dismissing her suit in respect of Schedule B property. So the decree of the trial court to that extent attained finality. On appeals, the Guwahati High Court reversed the trial court judgment. Being aggrieved, the present appeal has been filed. The Supreme Court has held that the plaint shows that the Schedule A property was given on lease by Maharani Chandradhara Devi to Hotel Kosh Mahal Limited. The plaintiff, however, did not place any document on record in support of this claim. Equally, defendant numbers 1 to 7 were not able to establish and show that Hotel Kosh Mahal Limited gave the property on lease to Maharani Chandradhara Devi. But the facts on record show that Hotel Kosh Mahal Limited was in possession of Schedule A property, though the nature and right to possession is disputed. Further, the plaintiff accepts that after 1968, Indian Airlines Corporation Limited paid the rent to defendant number 2 till Indian Airlines Corporation Limited vacated the property. The plaintiffs claimed that thereupon she took possession of Schedule A property and started a guest house is unsubstantiated or rather implausible. Not only there is no document or evidence to support the assertion, the possession would normally be given to the landlord to whom a rent is being paid. So the findings recorded support the case of the defendants. Further, it is clear that defendant number 8 came in actual physical possession of a portion of the Schedule A property. Similarly, defendant numbers 9 to 11 stated that they purchased portions of the Schedule A land based on sale deeds executed in their favor. In this factual background, this court would accept the claim of the defendants that on the date of filing of the suit, the plaintiff was not in actual physical possession of the Schedule A property. In order to succeed, the plaintiff has to establish that she has a legal title to the Schedule A property. The defendants cannot be dispossessed unless the plaintiff established a better title and rights over the Schedule A property. A degree of possession cannot be passed in favor of the plaintiff on the ground that defendant numbers 1 to 12 were not able to establish the right, title and interest in the Schedule A property. The defendants, being in possession, would be entitled to protect and save their possession unless the person who seeks to dispossess them has a better legal right in the form of ownership or entitlement to possession. The burden of proof to establish a title in the present case lies upon the plaintiff, as this burden lies on the party asserting the existence of a particular state of things based on which she claims relief. This is mandated in terms of Section 101 of the Indian Evidence Act. The said section states that burden of proving the fact rests with party who substantially asserts in the affirmative and not on the party denying it. In terms of Section 102 of the Evidence Act, if both parties fail to adduce evidence, the suit must fail. The shifting of owners of proof happens when the plaintiff is able to create a high degree of probability to shift the owners on the defendant. In absence of such evidence, the burden of proof lies on the plaintiff and can be discharged only when he is able to prove title. The weakness of the defense cannot be a justification to decree the suit. In the present case, the plaintiff could have succeeded in respect of Schedule A property if she had discharged the burden to prove the title to the Schedule A property, which squarely falls on her. This would be the true effect of sections 101 and 102 of the Indian Evidence Act. Therefore, the plaintiff should have satisfied and discharged the burden under the provisions of Evidence Act, failing which the suit would be liable to be dismissed. Thus, the High Court rightly set aside the judgment and decree of the trial court.